Welcome to Business Line's State of the Economy podcast, where you'll find insight, analysis, and the story behind the numbers.
Hey there, welcome to the BL State of the Economy podcast. I am Shrivats from Business Line, and today we have a very interesting topic at hand, which is the draft digital competition bill, a boon or a bane. One of the key aspects of the proposed digital competition law is its focus on preventing abuse of dominance by digital platforms. By imposing stricter regulations on dominant players, the draft law seeks to foster a more level playing field for smaller players and startups. The draft digital competition bill, framed by the center appointed inter-ministerial committee, when enacted into a law in the current form, would lead to introduction of ex-ante measures for regulating the big tech. Put simply, ex-ante measures in competition law refer to proactive regulatory actions taken by authorities to prevent anti-competitive behavior before it occurs. These measures are aimed at addressing market structure and dynamics to promote competition and prevent market distortions rather than reacting to specific instances of anti competitive conduct after they have already happened. The introduction of ex ante measures are likely to lead to significant oversight on certain pre identified large enterprises, namely the big tech, and their behavior in the market will be proactively monitored. They will be fastened with certain obligations on an upfront basis as regards their market conduct. The report and the draft bill has recently been exposed for stakeholder comments. The last date for submission of views is April 15th. The 16-member inter-ministerial committee had in its report not only recommended the enactment of a separate digital competition law but also framed a draft bill. The digital panel has recommended ex ante measures to complement the current ex post framework by identifying large digital enterprises with a significant presence in India in selected core digital services and setting predetermined rules for their conduct. The CDCL recommendations are largely modeled on the EU's Digital Markets Act with some India specific variations. To help us better navigate the salient features of the draft bill and its implications for the digital markets and players in the ecosystem, we today have Dinu Muthappa, a partner at the Delhi office of law firm Talwar Thakur and Associates and a member of the firm's competition law practice. With almost 15 years of practice, Dino has advised clients in complex competition law issues including abuse of dominance, merger control, cartels, and leniency, antitrust litigation, and compliance across various sectors including digital markets, pharmaceuticals, healthcare, media, and FMCG. Dinu is involved in a number of high profile abuse of dominance enforcement cases, including several major investigations into the digital markets. Most recently, she has successfully represented the Match Group in its antitrust litigation against Google before the CCI and appellate authorities, including the Supreme Court of India, resulting in groundbreaking and precedent setting remedies. Dinu, who obtained her LLM in competition law from King's College London, is also one of the few practitioners in India to have worked with the CCI from 2015 to 17, where she served with the office of the chairperson. Welcome to the BL State of the Economy podcast, Dinu. So, first of all, I would request you to take our listeners to the issue, which is that does India at all need a new digital competition law?
Sure. The Digital Competition Act, which is currently being proposed and is hotly debated, is the result of a months-long consultation by a committee which was set up by the government. The committee was set up specifically to assess, do we today, in the state of our economy, require a competition law specifically to apply to these digital companies or entities? Now, why is that the case? One, because digital companies have not only grown to be one of the most powerful in the world, what happened is that they have entrenched and expanded their power beyond their original markets or their core sectors in which they were once active. And nobody can deny the inherent benefit that these companies bring to all of us in terms of innovation, growth, technical development, and social economic mobility. But these markets also have some distinctive features. Typically, these markets end up becoming winner take all markets where your first mover gets such a significant advantage. And once these markets tip in favor of one or more players, then you have almost no contestability left. They almost become near monopolistic markets. So the problem here is that once a company holds so much market share and power, consumers and people who are running businesses on these digital platforms, they become wholly dependent on the entity. As a result, by the time you have any competition law enforcement, it is too late. The market has tipped in favor of the incumbent. Now, CCI, we already have an existing competition law, and a number of critics are out there who will say the existing Competition Act is sufficient. But the problem is that one, CCI proceedings are very long drawn due to procedural issues and natural justice requirements. The second thing is interim relief is not always available. It is precisely to ensure timely market correction that you have such a law.
Got that. Now, the point that has come for debate is that do you think enacting a digital competition law will heighten innovation in India, given the development journey that Indian economy is going through? Do you see it as heightening innovation in the country, or do you see it as one that will stifle innovation?
Sure. See, the fundamental aim of the law, the preamble as you may call it, is to remove entry barriers and promote contestability. Now, the objections which are largely coming is that it will hamper innovation are driven by some form of self-serving commercial motivations. Concern that Indian economy is not advanced enough to bring in these ex-ante measures. Now, this law will not apply to early stage startups. It's not intended to apply to smaller entities. It's only intended to apply to large, systemically significant digital enterprises, or what in other countries or in other jurisdictions people are calling as gatekeepers. Right? Now, big tech, one cannot afford for this law to impact their investment because their business model is only driven by data. And in that sense, the Indian economy provides a very valuable data set. This law, in its current nature, is not intended to apply to every digital entity, only to those large enterprises who are operating core digital services. Only they will be subject to this law. And even then, the manner in which the law is phrased, there is enough room for different conduct rules to be applicable for different digital services. So just because, let's say, you have one market, such as, let's say, search, online search, which may not be very contestable, that may not have the same rules as food aggregation, which today may be far more contestable. So the rules will be based on the nature of the market itself and also the size of the entity in question.
Sure. So already ever since the draft bill became public and the Committee on Digital Competition Law report recommendations became public, we are hearing two sides contesting each other. There is a section which says that India does not need ex-ante framework, and there is a section of experts and industry like startups who say that the time is ripe for India to go in for an ex-ante framework. So, which camp do you stand, and what is your take on that?
My take is that the intention of the law is good, Shrivats. My take is we are learning from other jurisdictions that ex post enforcement, which is post facto enforcement of the law, is not resulting in timely intervention. And these rules that are proposed in this law, they are not novel, they are not new. They are based on either existing CCI cases, decided CCI cases, market studies, and global best practices. So there is nothing new that is being served up to apply. The only difference is that now the entities will have to comply in advance rather than post facto, and you do away with the litigation. One would also say that big tech potentially should be in favor of such a law, because then, one, the rules are clear, two, the regulations will specify exactly what you can and cannot do. This will prevent unnecessary protracted litigation and ultimately hefty penalties, which today are going to be up to 10% of global turnover.
Sorry to interrupt. The pain point in the ex post framework that we have has been primarily on two counts. One, the delay in the litigation, and the point that the time taken by CCI to bring in the market correction.
Correct.
So, why cannot the government amend the existing law to give a statutory cap, like the insolvency and bankruptcy code, and say that all proceedings should be completed by a particular time? That could solve the problem, isn't it?
So, Srivats, when the law was enacted, initially also it was the Competition Act, not this draft bill. The Competition Act was also meant to have speedy redressals. One of the first ever cases under the Competition Act, which reached the doors of the Supreme Court. The Supreme Court has held in one of the most important judgments under this law that there should be an attempt to finish an investigation within 60 days, and speedy and expeditious disposal of cases is essential to a free market economy. Now, every competition lawyer will tell you the average time a case takes before CCI is between 2 to 3 years, because some of these issues do require time and deliberation. Number two, there are so many appeals. I mean, the appeal process itself can be so lengthy because we do not have a specialist tribunal dealing with competition appeals. There used to be one, but it was done away with. So by the time you start a case before CCI and you culminate that case in finality of proceedings in Supreme Court, is nothing short of a 7 to 9 year duration, in which time in any digital market, that market would have changed completely because of the data driven advantages that are and network effects that are key features of these markets. The first mover and the incumbent will have these advantages and grow to a size after which intervention will be too late. So the intention of this law is clear. The principles are the same as that already exist. What is only happening is that intervention is ensured as being timely. One of the aspects of this law to work is that, one, you have to make sure you have to ensure that compliance actually is effective. You don't end up slipping back into this enforcement model of investigation, appeal, so on and so forth. And you also have to ensure that at some level there has to be a trust based regulation on both sides, from both the regulator as well as private industry.
So, you feel fastening obligations on large identified entities could solve for the problem in the digital markets?
In digital markets, and because duration of these cases is such that they're unlikely to have to be disposed of in an expeditious manner.
Okay. So, if I understood you right, you are in favor of enactment of a separate digital competition law and also putting in place an ex ante mechanism in that law.
That's right. And I think another salient point to note here is that you see, not only when I say these measures are not new, because these rules already exist in the existing act, but these rules on an ex-ante basis are also being enforced in other countries and other jurisdictions. Now, these gatekeepers are global entities where they comply with such other jurisdictions as well. There should not be a reason not to thereafter apply the same standard and the same yardstick to India.
Got that. So now, for the benefit of our listeners, can you take us through the structure of the law? How does this law play out? What are core digital services, and what is the criteria on which the large entities will be identified and obligations will be fastened on them?
Sure. So, Srivats, the manner in which this law is framed is that it's intended only to cover what is known as a systemically significant digital enterprise, what is known as SSDE. Now, a company can become an SSDE if it exceeds certain thresholds. There are certain tests within the law itself. If you meet these thresholds, you'll be designated as SSDE. In fact, the law requires you to self-assess and designate yourself and report that to the commission. Now, what is this threshold? It's a two-step threshold. One is there is a financial strength test, which is depending on your size, your turnover, your capitalization, depending on your financial strength is one aspect of the test. The second aspect is a spread test, which is it depends on the reach that you have as a company by reference to either the number of users on your platform or the number of business users. So it's a twofold test. If you are of sufficient size, which is with reference to financial turnover or market capitalization, or with reference to users, which is your spread. If you meet both of these thresholds, you will be designated as what is known as SSDE. It's also important to note that the Commission has retained the power in this law that even if you do not meet the financial thresholds, you could still thereafter be designated as an SSDE if you satisfy certain qualitative thresholds which are explained in the law. Now, once the commission has determined or you have reported that you are an SSDE, the law will then apply to a pre-identified list of digital services. This is known as core digital service. These are services which are defined within the schedule of the act itself. So, for example, if you are an online search engine, if you are operating a social networking services, if the SSDE has a video sharing platform, there are certain predefined core digital services which the commission has identified. If an SSDE provides those CDS, those core digital services, then it must follow certain rules. Those rules within the act are in relation to conduct rules of, not self-preferencing, of not tying goods together. There are a number of rules. So it's in a sense a three-step process. One, are you an SSDE? Two, are you an SSDE providing a core digital service? And three, once you are providing that core digital service, these are the rules that you must follow. And if there is non-compliance, then there is a separate enforcement mechanism under the proposed law.
So in essence, if I am an entity that qualifies to be an SSDE, then I will be forbidden from undertaking upfront any anti-competitive conduct which has been identified, like self-preferencing, bundling. Is that the case?
That's right. That's right. So once you are SSD by virtue of your size and you are engaged in providing any of the core digital services which are pre-identified, then in relation to that core digital service, there are certain things that you should not do. One of these is that you should ensure you offer only FRAN terms, fair, reasonable, non-discriminatory terms. You should not do tying bundling. You should not do self-preferencing. You should not restrict third-party applications. So there are a number of these conduct rules. And the one thing I will add here, Shrivats, is that these rules, like you said, this anti-competitive conduct which is identified, these obligations are broad-based, they are principle-based. The nitty-gritties will actually be expanded by the CCI in regulations which will be issued under this law. Now, the act itself has a broad-based principle, but the regulations will go to the heart of the matter. And it is hoped that the regulations will be introduced through a consultation process, where at that moment of time, industry can also give valuable input to the CCI as to the manner of the framing of the regulations. And it may also help the CCI to do this after we have had maybe some time of enforcement of similar ex-ante measures in other jurisdictions, because we will be able to learn manners in which companies are complying and not complying or trying to evade ex-ante measures in other jurisdictions, and maybe we can clarify those to adequately capture that anti-competitive conduct in our law.
So that takes me to the bigger question that I have, which everybody is talking about. Do you see the structure of this bill being an outcome of a large influence of the EU's Digital Markets Act, or do you see it as an amalgam of the EU's DMA and the UK DMCC bill?
See, I think the motivation behind it may have been inspired by other legislation. Let's not forget, yes, the EU has the DMA, the UK has draft legislation, as does the US. Germany also has a separate ex-ante regulatory measure. The motivation may have been gleaned from there, but the law itself is a little different. For example, the DMA obligations are far more specific, whereas the law here is only to highlight broad-based obligations. These obligations will then be clarified through regulations. So one is for certain aspects of the law, I would also say, could do with further consultation and revisitation. But it is not necessarily a copy paste of what exists in other jurisdictions.
So are there elements where we are better than what the EU has in force?
So you see, Shrivats, there are a few provisions under the EU DMA which, on first glance, one could say are potentially missing in this law. The DMA provides for tackling price parity, which is your typical MFN arrangements in digital platforms. That does not appear to be specifically provided in this law. Similarly, interoperability also does not appear to find any mention in this law. The EU DMA also specifically has something in relation to ad tech transparency mandates, which is also not covered here. Now, one can argue that under the more broader principle here of fair and transparent dealing, what we are now reading as the FRAND clause, that once the regulations are framed under this clause, then it may cover some aspects. It may cover MFN issues. It may cover ad tech related issues. So of course, I would say that this law is still a work in progress, and the legislative process in India is itself a long one. So not only will we have opportunity to comment on the law, because the MC has given stakeholders till April 15th to comment, but also on the regulations itself, which will fine tune and hopefully even cover any holes that we may see from foreign jurisdictions also.
Great. So going back to the SSDE, right? One aspect which I would like you to talk about is having qualified on the criteria, either the quantitative or the qualitative criteria.
Yes.
I believe the EU DMA gives an opportunity for the entity concerned to avail an exemption from the obligations. So, do we have a similar framework here? Because I didn't find any exemptions being explained in the bill.
See, this in relation to this, I would say two things. One, the commission has had sufficient expertise now to be a regulator and to be an expert in this area. That's why Big Tech is also arguing that the commission alone should ex post enforce this law. The commission will specify through regulations what has to be done and not done. The commission will also specify in relation to different obligations, materiality thresholds with reference to number of users as well. So just because the committee has in fact stated in the report that there are some markets which are still contestable and tying and bundling may actually be pro-competitive. But there are some markets which are anti-competitive and sorry, there are some markets which are not contestable anymore, and in those markets tying and bundling may already be anti-competitive. So the commission has the law provides for the commission to retain the ability to define different conduct rules in different thresholds. So that is a manner of speaking one type of exemption. It will be for the commission to assess. But once and the assessment of what is an SSD, I doubt will be taken very lightly. While the thresholds at first glance appear very low, one should not, forget the intention. The other point I want to add here is that, when in the framing of the regulations, the law provides that there are certain factors to be kept in mind. Those factors are in relation to prevention of fraud, cyber security, infringement of IPR. So these kind of factors will be built into the regulations, and while doing that, then the commission could treat those as exemptions as well, or relaxations of certain rules. So there may not be exemption to you by virtue of your size, but there may be an exemption to you by virtue of the CDS in which you are involved in, and the regulations framed thereunder.
Got that.
And lastly, I believe that the central government, not the CCI, but the central government has an overarching power to exempt certain enterprises from the application of the law. But this is a very rarely used exemption, I would say, in the sense it's a similar exemption for the existing Competition Act. So one would not expect this to be exercised willy-nilly.
Got that. Now, talking of the thresholds, I'm tempted to ask you to compare the Indian threshold on the number of users, the number of business users,
Yeah.
right? The number we have put in the draft bill is 1 crore end users and 10,000 business users.
That's right.
Now, if I compare it with the EU,
Yes.
and mind you, India is at least 4 times as big as the EU population, right?
That's right. That's right.
Yeah. So why cling on to the same 10,000 business users? Why are we keeping the threshold so low? Because
So,
it's
yeah.
10,000 business users both in the EU and in India, right?
That's right. That's right. So the EU test, so that there are a couple of differences. One is that the EU test is with reference to, as you said, 45 million end users and 10,000 business users. So if you will be an SSDE or in the EU gatekeeper, if you have 45 million EU users and 10,000 business users. Now here under this law, it is not an and, it is an or. So even if you're a platform having just end users, or even if you're a platform having just business users, this law will apply to you. And you may be an SSD if you hit these numbers. Now, just in terms of the number itself, the threshold itself, the reference in the EU is about 1/10 of its total population, broadly speaking. Whereas over here, our end user test is 1 crore, whereas our population is nearly 100 times that number. So therefore,
140 crores.
yes, yes. So we are looking, so if you, it's not an apples to apples comparison at all, and that has been a big critique of the law, in that the end user number is extremely low. even if, let's say, we were to reference not to our total population, but only with reference to our internet users, we still have around, I think, 80 odd crore internet users. And even still then, the end user threshold is very, very low. The relevant end number, if we were to apply the EU test of a 10% of population, if we were to apply to our internet penetration, then our relevant end user number would roughly be around 8 or 10 crores. So that is one critique of the bill. The other is business users has been the number is almost similar to that of the EU. But one may also argue that, we may have a greater population in the EU, but we may have far less business users. So, but in fact, this is going to be a policy mandate, and I think as a result of due stakeholder consultation, the numbers will be changed.
So this is an aspect that you feel needs a rethink.
That's right. I think it could be worthy to have a rethink especially after the consultative process. That being said,
Okay.
Shrivas, I would, however, also say that just because a digital platform meets these numbers does not necessarily mean, these rules will apply. You'll first have to see whether it, is in any of those core digital services, and if the commission for those, because the commission retains the power to specify different conduct rules for different CDSs, it may be tweaked accordingly. Even though this law uh, is agnostic of the nationality of a company, you may not want to target, what is a thriving Indian digital startup sector.
True, but if the law requires self-reporting,
Yes.
uh, keeping the bar low could be a ploy to spread the net wide, right?
Yes. The idea may be to spread the net wide and then to specify rules only in very, very rare cases. But the manner in which it's currently drafted, if we were to do a plain reading, it may have an unintended consequence of capturing several other companies, which may not truly, in the sense, should be considered as gatekeepers or SSDEs.
Okay, so now tempted to ask you the next question, which is that do you see the law, if enacted in the current form, influence? How do you see it impacting big tech conduct? Do you see a sea change in their approach to India?
That's a good question, Shivats. See that if there is no compliance, then this law will be toothless, to put it quite frankly. Uh, there are, of course, a million ways in which companies can, through, finding loopholes and zigzagging around and, making the compliance so onerous, almost, result in de facto non-compliance. This is very well a possibility of this law. That is why what I had mentioned earlier, I will say that it may behoove us to uh, refer in the framing of our regulations those practices that we are seeing from ex-ante enforcement overseas, because there is, at least in relation to some companies and their alleged non-compliance, um, a lot of well, the people are being very vocal about their non-compliance, because ultimately, I think perhaps at some level the intention is not to comply. And this goes back to my earlier point, which is that if these laws are already in place for big tech to comply, then ideally, the provision of clear prescriptive rules without ambiguity and clear regulations should actually be in favor of big tech rather than saddling them with unnecessarily prolonged and expensive litigation and heavy penalties.
So net, what is your take? Will big tech have sleepless nights about this law getting enacted?
I don't think they'll have sleepless nights, Srivats, because there are already obligations, similar obligations in other countries, jurisdictions, draft legislations. I think it was potentially a matter of time before it hit the Indian shores also. It may not cause sleepless nights, but there may be definitely time lags in its enforcement.
Got that. So, my last two questions, one on this aspect of the framework proposed law, digital competition law, leaving it open
Hmm.
for CCI to, do double case initiation,
Yes.
one under the digital competition law and also under the existing competition act. Is that gap there? Is there going to be a room to penalize the same entity twice?
See, the intention, of course, is not to punish a company twice for the same type of behavior. In fact, I think the committee has already taken note of the fact that there could be overlapping proceedings against the same entity under this Digital Competition Act and competition law. And you could potentially, one, have contrary outcomes or even penalties. It could go both ways. Now, the committee recommended that the CCI can deal with such situations on a case-to-case basis. If I was the CCI, I would look at this law as the opportunity to implement, at least in the very first instance, only against large entities. What is the point of penalizing a company or enforcing compliance here when you can also have maybe commitments or settlements under an existing proceedings? So it's unlikely for the CCI to have to enforce two overlapping laws only for the purposes of penalization, and it will be up to the CCI's best judgment as to which proceeding may result in the more favorable and the more timely outcome. One fear is that this could also then be used by companies to stay or challenge or put legal hurdles saying, compliance has happened with A and therefore keep in abeyance B. But compliance with A may not be truly, the compliance which is intended for market correction.
So, in essence, we need a tweak in the law to ensure that there is no double case on the same aspect.
That's right. That's right.
So,
I would say
right.
that, and also separately, even jurisdictional overlap issues. There are some aspects of this law which could have overlaps with intellectual property rights, could have overlaps with data privacy issues. There is a provision in the bill currently, which says that which provides for a consultation mechanism with other regulatory agencies. And this provision is there in the existing law, but it has not been very fruitful and not been exercised also. So it potentially this law could do with some improvement on that front, on jurisdictional overlap with other regulatory bodies.
Great. So, my last question to you, Dino, is that on side loading of apps, which is
Yes.
of tremendous consumer interest in India,
Yeah.
this bill seeks to give statutory backing for side loading of apps. So, help me understand what are the implications of this move.
Well, you see, this bill contains a very express provision requiring that an SSDE should not restrict or impede the ability of users, end users, and business users to download, install, and operate third-party apps. So, therefore, to allow sideloading. Now, what has happened is that over a period of time, our app distribution mechanism has become dependent on the two incumbents, on Google and Apple. And this is playing out in app store litigations across the world, whether it is in the US, in the EU, or in India. And this over dependence people have seen is tending to be exploited by these gatekeepers. So the allowing side loading is a measure of maybe reducing the reliance on the gatekeepers and introducing a more equitable operating system marketplace and ensuring a more equitable app store marketplace. But you see, security concerns also have to be taken into consideration. Um, and while there is no outright ban on side loading, developers should be given some leeway to introduce measures to ensure side loading does not lead to security issues. So it has to be a careful balance where it can't be an abject prohibition by the OS owner, but you should also potentially have some room for the OS provider to also build in security measures. The way it currently exists is that there is no sideloading at all on the Apple system. And the Google system sideloading is extremely onerous, which throws up 17 or 18 different security warnings. So, maybe a balance of the two, where you permit sideloading to ensure more equilibrium and open marketplaces, but also to ensure that some element of safety and security is kept in mind.
So, in essence, this would favor the development of the Indian ecosystem.
That's right. That's right. And I think the other important part is that the question, what is safety, what is integral to safety, what is security, these items can be clarified through regulations. It cannot just be a fallback safe excuse to prevent sideloading.
Great. So, Dino, we are coming to the end of our podcast. So, to conclude, can you help us understand what is your overall message
Yeah.
on the title of the podcast, which is that is the draft competition digital competition bill a boon or a bane? What is your take on that?
See, my belief is that ultimately this is a boon to the Indian economy, to the Indian digital ecosystem, to small players and to large players. These obligations are no different from what is already there in law that ought to have been complied with. What this law does is it ensures timely market correction, so that we have more contestable digital marketplaces. Given the nature and the size of the Indian economy today and our number of unicorns, how we have managed to develop and promote the Indian digital economy, this law will hopefully help us and help raise all of us in terms of help us in creating truly competitive and contestable digital markets for our country.
Excellent. So, thank you so much, Dino, for all your perspective and valuable insights on the digital competition law. I guess by the time we get all the feedback and the government gets the feedback, hopefully we will set the stage for the enactment of this law in the upcoming monsoon or the winter session. So,
Yeah.
thank you so much for your perspective and for joining us at the BL State of the Economy podcast. Thank you, Dino.
Thank you. Thank you so much, Shivas.